This lecture deals with the materials covered in Chapter 4 of the textbook, which deal with classification of the law. This chapter serves as an introduction and overview to the upcoming chapters on torts, contracts, property, and criminal law. The last couple of weeks, we have been going over various sources of the law, and we learned that American law derives from legislative, judicial, and administrative sources. Chapter 4 deals with various classifications of law within those sources, and it's broken down into three main categories: federal law versus state law, criminal law versus civil law, and substantive law versus procedural law. Again, all of these will be dealt with in more detail in coming chapters. This chapter 4 just serves as an introduction and overview. This slide comes from the textbook, figure 4.1, and shows how the classifications can be further broken down. You'll see on the left-hand side, state law, the right-hand side, federal law. Under both categories, we have both civil and criminal law. And within each category of civil and criminal law, we have both substantive and procedural aspects. And as noted, substantive aspects of civil law include things like tort law, contract law, property law, etc. The procedural aspects of civil law include statute of limitations, issues regarding jurisdiction, etc. On the criminal side, substantive areas of law include the various types of crimes: battery, larceny, assault, etc. While procedural aspects include the Miranda warnings, the right to an attorney, search and seizure limitations, etc. All right. The first distinction we make between laws is federal law versus state law. As noted in the slide, each of the 50 states and the federal government itself has its own legal system. This derives from the federal system of government that we operate on. Federalism is a system of government. It's not unique to the United States, but in which authority to govern is split into a single nationwide central government and regional governments that cover specific geographical areas. And again, federalism is present all around the world. You just have to look north of the border in Canada, south of the border in Mexico. Both of those countries have federalist systems of government. When we have federal law, we have the sources of law that we talked about. We have constitutional law, we have federal statutes, and regulations issued by federal agencies. State laws, on the other hand, relate to the health, welfare, safety, and morals of a state's citizenry. State laws cannot violate the United States Constitution, but apart from that, each state is free to create its own laws. This gives rise to our system of government, where different states have different legal systems, different areas of substantive law, etc. Figure 4.2 of the textbook compares federal and state laws, and the chart shows the difference between who enacts the laws on each side and provides examples. For instance, in the federal law, the Congress enacts laws. The basis for that must be found in the Constitution, etc. While the state laws are enacted by state legislatures, and they're hamstrung only to the extent that they cannot enact laws that are prohibited by the Constitution. State laws, by and large, relate to the welfare of citizens and include things like divorce laws, gambling, landlord-tenant, criminal law, etc. On the other hand, federal law it relates to national matters, income taxes, regulation of interstate commerce, etc. The Supremacy Clause is something that we've talked about. It's a provision of Article 6 of the United States Constitution that states that the United States Constitution and all laws and treaties made in accordance with the Constitution are the supreme law of the land. In other words, state laws cannot be in violation of the United States Constitution, and neither can federal laws for that matter. And again, the Supreme Court is the ultimate determination or determiner of what is constitutional or not constitutional. Again, the preemption doctrine does not prohibit states from enacting laws into areas that are governed by the federal laws, as long as they do not conflict with federal laws. Again, if there is a conflict, then the federal law will prevail. Federal law, a lot of people have the idea that federal law deals with major things and state law deals with minor things, and nothing could be further from the truth. State laws apply to major transactions, to serious crimes. Just because something is a huge deal, a big crime, a big financial deal, doesn't mean that state law will not apply. It couldn't be further from the truth. On the other hand, there are types of cases where both federal and state laws will apply. The textbook gives the example of the 2013 Boston Marathon bombing. Two brothers murdered 3 people and injured over 200 people with bombs at the 2013 Boston Marathon. Some of those people that were injured were horrifically injured, lost limbs, etc. The surviving brother was charged with both state and federal crimes arising out of the action. The textbook also points out that the surviving brother could have been charged with civil suits, or people could have filed civil suits against him seeking monetary damages. The reason that by and large wasn't done is because civil cases, again, seek to recover damages. He had no assets, so litigants were not motivated to sue him. Another instance of showing both state and federal prosecution include the 2015 bombing of a church in Charleston, South Carolina, by a man named Dylann Roof. He was a neo-Nazi white supremacist. He bombed an African-American church during a Bible study, killing 9 people, including the senior pastor and a state senator. All of the victims were African-American, and Roof confessed to wanting to start a race war. Roof was charged with both federal and state crimes, and in fact, he was tried on the federal level first and actually received a death sentence. The state of South Carolina then entered into a plea bargain with Mr. Roof, where he confessed or pled guilty to the counts of murder, receiving a sentence of life without parole. And the idea behind that plea bargain is the state of South Carolina had no incentive to seek anything more against him. After all, Mr. Roof could only be executed once, and the plea bargain allowed the state to save significant money and resources in having to try the matter. State laws can vary from state to state, and again, as I mentioned, different states allow for different types of conduct to be legal. The shakeup in the abortion laws that arose out of the Dobbs decision means that abortions are legal in some states, illegal in others. Similarly, gambling is legal in some states, illegal in others. Things like use of marijuana, legal in some states, illegal in others. So again, this shows the effect of our federal system and the effects that it has. Many of our criminal laws deal with the subject of public morals. Again, think about laws against prostitution. Prostitution is legal in some areas, illegal in most. Again, drug use, drug laws like marijuana laws are looked at as essentially moral type of laws, and different states treat them differently. So again, if we have a conflict between state and federal laws, generally the federal law will prevail. However, the federal government is prohibited from acting in laws where it is not authorized to do so. And the 10th Amendment to the United States Constitution reserves to the states all power not conferred on Congress by the Constitution. All right. The next a breakdown between categories of law. Again, we talked about state versus federal. We also differentiate law between civil law and criminal law. As noted on the slide, civil law is the area of law that deals with harms to an individual, whereas criminal law deals with harms to society as a whole. The slide in front of you breaks down the different areas covered by civil and criminal law and summarizes the differences. Again, civil law deals with private injuries, criminal law deals with harms to society. In civil proceedings, the names of the parties are the plaintiff and the defendant, whereas the criminal proceedings, it's the state against the defendant. The person that brings, or the party that brings the action, is different in civil and criminal proceedings. In civil proceedings, it's usually an individual, although sometimes it can be the government suing civilly, whereas criminal matters are always filed by the government. And finally, the standard of proof is different in each type of case. In civil cases, it's preponderance of the evidence. Criminal proceedings is beyond a reasonable doubt. It should be pointed out that beyond a reasonable doubt does not mean beyond all doubt. It means reasonable doubt. When you think about it, we could have a doubt that the sun is going to rise tomorrow. Certainly that's a possibility. Is it reasonable? No. So if you hear somebody arguing on a TV or a movie trial where they have the defense lawyer saying, you must be convinced beyond all doubt, that is absolutely not true. And if a lawyer said, defense lawyer said that, they would be scolded harshly by a judge. That's simply not the case. The civil standard of proof, on the other hand, preponderance of the evidence, simply means more likely than not. Okay, the different types of remedies result in civil and criminal law. Against a civil matter, the defendant is either liable or not liable, whereas a criminal case, they're guilty or not guilty. In civil cases, primarily we seek damages for wrongs or injunctions, prohibition against engaging in certain conduct. On the other hand, in the criminal area, the sanction can include imprisonment, fines, or in some rare cases, the death. And again, finally, the source of criminal and civil law are different. Civil law comes from both common law and statutes, whereas criminal law is wholly statutory. Criminal law deals with harms to society as a whole. And we break down criminal law cases between felonies and misdemeanors. The slide indicates that serious felonies are serious crimes that carry a prison sentence of 1 year or more. These are served in state prisons, whereas misdemeanors are minor crimes, usually punishable by a fine or jail sentence of less than 1 year, with the jail sentence to be served in a county facility. Again, even though we say that criminal law deals with harm to society as a whole, it also primarily deals with harms to individuals. Does that mean that the individual is in control, or the victim is in control of the proceeding? The answer is no. An example of this would be a spousal abuse case. Oftentimes, following an event of spousal abuse, the abused spouse may not want to, quote, press charges, close quote, against their assailant. Perhaps they've got together, or maybe it's an abusive relationship. The government does not have to respect the wishes of the battered spouse. The government can, and often does, prosecute spousal abuse cases as crimes over the objection of the battered person. Again, the idea is, although an individual was harmed, it really was a harm to society as a whole, and with the idea of deterring future episodes of spousal abuse. In a criminal law case, we have two elements that must be present in every case. Of course, you have to have the bad act, but you also have to have the bad intent. And we have the Latin terms mens rea and actus rea. Again, without a bad act, you usually do not have a crime, although you could have an attempted crime, the attempt being the bad act. But again, you have to have the bad intent. If that bad intent is not present, we don't have criminal activity. Once the prosecution sets forth their case, the defense may then present evidence that contradicts or establishes some kind of justification for the action. And those defenses could be an alibi, just be an attack on the evidence, could be a justification by self-defense, or ultimately insanity. Again, civil law and tort law refers to private actions brought by individuals to address wrongs. Civil law seeks to recover damages for those wrongs by and large. And again, we contrast that with criminal law, which deals to harm to society as a whole. In a civil law action, the plaintiff also has the burden of proving their case, and they do that by proving the elements of the case pursuant to a cause of action. A cause of action is defined then as a legal claim that gives supported by facts that support a lawsuit. If we don't have a valid legal claim, then the court will dismiss it. An example of that might be generally a witness to an accident doesn't have standing. We talked about that to file a lawsuit. If that individual did file a lawsuit seeking damages that they suffered as a result of being a witness to the accident, it would be held that that action does not state a valid cause of action, and the case would be dismissed. On the other hand, assuming that the defendant is proper, in a civil case, like a criminal case, a defendant has a right to contest it. One of the ways to contest it is by showing affirmative defenses. We'll learn about affirmative defenses in the following weeks. These are matters that must be proved by the defendant that can either eliminate their liability or at least reduce it somewhat. Civil law, the ultimate goal of a civil law case usually is to recover damages. We break down damages into three different types. Compensatory damages are money that compensate the victim for the harm that they suffered. Punitive damages are, on the other hand, really have nothing to do with the harm to the victim, but rather they're designed to punish the wrongdoer. It should be noted that punitive damages are only available in tort claims. You cannot recover punitive damages in a breach of contract action. And finally, there's this concept of nominal damages, where even though the damages may be almost nothing, you'll hear cases where somebody's been awarded $1. And there are a number of reasons why people bring actions that give rise to only nominal damages. We'll talk about those in the coming weeks. Finally, the areas that are governed by civil law, the text breaks them down into three categories: contracts, property law, and torts. And again, we'll be talking about all of these in the coming weeks. The last type of distinction of types of law discussed in Chapter 4 is the concept of substantive versus procedural laws. Substantive laws create rights and duties. Procedural laws, on the other hand, regulates how the legal system works. So a substantive law may forbid, for instance, an assault against somebody. A procedural law regulates how the legal system works with respect to that assault, i.e. the statute of limitations that might apply and different types of procedures involved in the trial of the matter. Figure 4.4 of the textbook set forth in this slide is a good summary of the differences between substantive and procedural laws and provides examples of that. So again, make sure that you review that and are familiar with that. All right, this concludes the lecture for Chapter 4 of the textbook. Again, this does not serve as a substitute for a careful review of the chapter, and I encourage you to do that. We will, as discussed, be covering all these areas in more detail in following chapters.